be used against you if the case were to go to trial. You also have the right to an attorney, and if you don't have private counsel and you'd like the assistance of the public defender, they are available to help you. If your case can be resolved today, I will let you know, and plea offer will be made to resolve your case if possible. Okay, I am going to call Montavious Dixon.
He's here, main judge.
Okay, thank you, counsel. Mr. Dixon, you are here. Is this a second look, or is this a motion for ROR?
It's a motion for release.
30 days.
Okay, and state, is there any, what's your position on the defendant's motion?
Looks like this charge is going to be declined. He still has a...
Looks like he's been state sentenced.
Well, he's state sentenced on one case, and he's got a $15,000. He's got a $200 bond on a criminal mischief and a $15,000 bond on an out-of-county date hold. So
Okay, so he's to be ROR'd on...
he'll be RR'd
This-
in this case. And
Okay. Mr. Dixon, the court's going to grant your attorney's request to release you on your own recognizance on charge number 5, the corruption of a public servant. Okay. Eric Lamar Thomas.
Mr. Thomas is here at main jail, judge. He's approaching.
Thank you.
Come on.
Hi, Mr. Thomas. Mr. Thomas, you're here on a domestic violence aggravated assault with a deadly weapon. You're also here on a domestic violence battery charge, and you have an open municipal ordinance capias.
just want to advise the... Oh, I'm sorry. I'll wait for the court to make a PC determination before I say anything.
Okay, Mr. Thomas, the court does find probable cause, and the state wish to be heard.
Your Honor, I just want to advise the court that our office had contact with both of the listed victims. They're both in great fear for their safety. As far as criminal history, Mr. Thomas has multiple drug priors, possession of cocaine with intent, delivery of cocaine, possession of cocaine. He has gone to state prison, from what I can see, twice in the past.
Okay, and what's the state's recommendation as far as a bond?
Your Honor, the state would be requesting, a moment, also noting that he made a specific threat to kill, Your Honor. I'm going to be asking for a $15,000 bond on one, $10,000 bond on two, order of no victim contact.
Okay, public defender wish to be heard?
Judge, in speaking with Mr. Thomas, he's been residing in South Florida his whole life. He's 43 years old. At this time, he is employed. He's a handyman. He's self-employed. His wages do fluctuate, but he's been doing this now for about 10 years. He makes on an average about $450 weekly. He will be living separate and apart from the alleged victims. He has members of his family that live in our community. He'll be staying with his father, who resides in Fort Lauderdale. We'd be asking you to take into consideration his financial resources in determining a reasonable bond for Mr. Thomas on counts 1 and count 2.
And I would just add, Judge, that one of the victims, even though she did say she was in fear, also indicated she did not wish to prosecute.
I understand that. Okay, so Mr. Thomas, on count 1, the aggravated assault with a deadly weapon, the court's going to set bond in the amount of $10,000. On the domestic violence battery, bond is set at $5,000. On your capias, you have a $500 bond, so total of $15,500. And the court's going to order no contact with either of the alleged victims. Michael Brandon Miller. Thank you.
So if we could be on recall?
Oh, okay, very good. Kenny Darius.
Mr. Darius's brother is present, Judge. His brother is present.
All right, would Mr. Darius's brother like to come up, or you just want to stay there? You're welcome to come up. Okay, Mr. Darius, I understand your brother is in court. What's your name, sir? Lubins? Okay. So, Mr. Darius, you're here on a number of charges. One is domestic violence, aggravated assault with a deadly weapon. You have domestic battery by strangulation, domestic violence battery, and false imprisonment. The court does find probable cause. And, Lubins, is there anything you wanted to say?
Lubins, this is probably not the best time to actually go into the facts of the case because everything we say is being recorded. I think what the judge would like to hear is what kind of person your brother is, where will he be staying, will he come back to court, have you known him to be a violent person in the past, those type of things. That's what.
Coming back to stay with my mom. We stayed together with my mom.
Okay. Okay, thank you. Okay, the court is going to set bond in the amount. Yeah.
If we can be heard before you make a decision.
Go ahead.
Mr. Darius, he's been residing in South Florida for 9 years. He's 26 years old. At this time, he's unemployed. He's scheduled to start tomorrow. He just got a job at a warehouse in the packing and shipping department. He's scheduled to be making about $11 an hour. From what he advised me, Judge, he has no money in the bank, no property. We'd be asking you to sign a photo order and ask you to give Mr. reasonable bond as to counts 1 through 4.
Okay, thank you. The court is going to set bond on count 1 in the amount of $7,500, count 2, $7,500, count 3, $5,000, and count 4, $5,000. The court is ordering no contact with the alleged victim, and the court will grant your attorney's request for photographs.
Thank you.
You're welcome. All right. Sheena Lynette Carter.
All right.
Judge, she was in custody when this case was in.
Okay, thank you. All right, I'm not getting any picture at Paul Ryan.
The paperwork's, the clerk's.
Is there anyone at Paul Ryan that could turn the monitor on?
It's all there. You don't have to wait for that. Just what you can do on it. Yeah.
Do they see? Okay. I'm going to put Ms. Carter on recall until we're able to fix the monitor.
Judge, I've been informed Mr. Michael Miller is now here. The case that was on recall.
Okay, thank you. All right. Michael Miller. Hello, Mr. Miller.
Hey, hello.
Mr. Miller, you're here on a violation of probation. There's a no bond hold. However, you do have a court date on May 30th. Good luck. Pamela Mendez Estrella.
She's also in Paul Ryan, Judge.
All right, I'm going to have to put her on recall also. We still don't have I still can't see the monitor at Paul Ryan. Thank you. Alexis Thades?
Ms. Thades, come on up, please.
She did. Okay, Ms. Thades, you were in court this morning? Okay, I'm going to take your case off the docket since you already saw the judge this morning.
Okay.
All right, good luck. Mackenzie Duperval?
Judge, she declined to serve as public defender.
Okay, thank you. Hello, Mr. Duperval. Mr. Duperval, you're here on two capiases for one case. One is a possession of cannabis, and the other is driving on a suspended license. You do have a bond in the amount of $1,000 for both of the capiases.
Yes, I know that. Actually, the warrant that was issued on the 2nd, I saw Judge Diaz on the 23rd, and he was supposed to motion all 3 cases, but they only did 1. And I was waiting for a court date that's supposed to happen tomorrow morning, and they came to my house to arrest me.
Okay, well, just so you know, the capias was issued.
On March 2nd.
Hold on. Okay, no, it wasn't March 2nd. It was before that. It looks like February 23rd.
Right.
Okay. Anyway, you do have these two charges that you have to deal with. There's $1,000 KP. It says $500 on each one.
Right, but what I'm saying is that the court took motion those, and then they didn't motion those 2. So I went to court to talk to Judge Diaz about these already. That's what I'm saying.
Okay, you do have a court date on June 1st. That's the only information I could give you, but these are active capiases.
I have one on the May 25th for these cases, which is tomorrow morning.
Okay. All right. The information I have is you have a court date June 1st, but if you're going on May 25th, then I wish you luck. All right, that's it, Mr. Duberval. This is the capias that's active. Damien Xavier Santana.
Mr. Santana is approaching, Judge. He did advise me that his sister will be posting his bond.
Okay, very good. Mr. Santana, your bond is in the amount of $600. The court does find probable cause, and as your attorney's indicated, your sister's posting bond. Good luck.
Your Honor,
Yes.
this is Paul Ryan. We're on now. I can see you now.
Yes, you are. Okay, very good. Thank you. Sheena Lynette Carter. Hello, Ms. Carter.
Hi.
Ms. Carter, you're here on a capias on a driving with suspended license charge. There is a $500 bond.
Yes, I was in custody the day that I was supposed to go to court, and I did message, asked if I would be transported, but they told me they don't transport to that division. I was in custody since May 6th.
Okay, is that the case?
She was being released probation in this case.
Okay, so the capias was issued in error, it does appear. The court is going to ROR you on this capias. You still have to go to court and resolve the case, but you're going to be released.
Okay, thank you so much.
You're
Thank you, Judge.
welcome. Pamela Mendez Estrella.
Good afternoon.
Hi, Ms. Mendez Estrella. Now, you are here on, hold on here. It's an order to take into custody that was signed. There's no bond,
Yes.
but you are going to be brought to court to deal with this grand theft charge.
Judge,
I was supposed
Ms.
to go
Mendez
today.
Estrella indicated to me she also was in custody when this order was entered. And she has 2 matters. The count 1 is a misdemeanor petty theft charge, which is also a no bond hold. And she has this juvenile court order on count 2. But I don't know. I don't know. Mr. Lender had a chance to look into it and maybe can give us some more information.
It's a little different than the other situation. It's one thing when somebody can't, pursuant to administrative order, can't be physically brought to a satellite.
Right.
I don't know why she wasn't brought. I don't know what happened that led to her juvenile judge issuing this capia, this no bond hold. I have no idea.
Yeah, I was in custody at the time. When I was supposed to go to court, I sent a message as well to the kiosk, and they just never transported me to court the day I was supposed to show up.
Was she in custody? I see the order was dated May 22nd. When was her calendar call?
It appears that she was arrested on the 17th, and this was on May 22nd. My only issue is, and that's why I was bringing up why it's different. We wouldn't have to be in a satellite courtroom to know what the issue was for why they couldn't be there. But none of us were in before the juvenile judge. For all we know, someone could have said, "Hey, judge, she's in custody," and the judge said, "I'm issuing this anyways," and then it would still be up to it still would be a matter that would have to be heard before that judge.
But it does say the reason why this order was entered was because she was a no-show.
Oh, I understand, and all I'm saying is it could have been brought, what I'm saying is, even if it was brought to a satellite judge's, Your Honor, I would just be objecting in this situation to RORing on a juvenile judge's pickup order without knowing more, without hearing from one of the, if there was an assistant public defender or a private attorney that was present that could say what happened in that courtroom that led to what specific reasons, and I understand what's written here, but.
Okay.
Judge, normally, excuse me.
Yes.
Normally, she's here on a VOP misdemeanor, no bond hold, and once we get someone to so she'll go in front of the juvenile judge, but she don't know.
Okay. So in this case, what I'm going to do, since she was in custody when this order was entered, I am going to ROR her on this grand theft charge. But Ms. Mendez, you're not being released because you're also in custody on a no bond hold.
Okay, but when will I know when I'm gonna get a bond? Because it's a VOP charge, but they told me that within 7 days they would let me know what was gonna happen. And this is my first time being in court since then.
Do you have a court date?
Let's see here. I don't have a court date on her paperwork. Does she have a court date, Madam Clerk? No. Okay. You do not have a court date. You have an attorney?
No.
Okay. You could find out from the judge when your next court date is going to be, but I don't have any information here.
I don't know who my judge is because I got arrested when I was at my probation. So I don't know who it is either. They haven't really told me any information.
See Judge Diaz on Friday.
Okay.
Looks like the public defender has been appointed.
All right. From what the assistant state attorney is advising the court is that you have a court date on Friday to see Judge Diaz.
Okay.
All right.
All right,
Good luck.
Thank you.
You're welcome. Kyle Wilhite.
Mr. Wilhite, is your
Okay, Mr. Wilhite, you're here on a failure to report as a sexual offender. The court does find probable cause, and the state wish to be heard?
Your Honor, the state is going to be requesting a $15,000 bond and pretrial release with a GPS monitor. It appears that Mr. Wilhite was extradited to South Florida from New York. It appears, that's part of the concern. Based on the allegations, he wasn't registering. No one had any idea if he was in South Florida or not. The charge is filed, and then he ends up getting arrested in Nassau County. The underlying offense for where he's registered is out of Indiana, so I do have concerns that he doesn't have ties to the community, that he, I think it's mentioned in the probable cause affidavit that he is transient, so.
Okay. Public defender wish to be heard?
Judge, at this time, the only thing I wish to share with the court is, in speaking with Mr. Wilhite, he's financially indigent. At this time, he has no money to make, no property. I'd ask you to consider that in making your determination.
Okay, thank you. Mr. Wilhite, after hearing the argument from counsel and reviewing the information that's in the reports, the court is going to set bonds in the amount of $15,000 in order, if you are released from custody, that you are to wear a GPS monitor through pretrial release. you have, if it says here in the report that if you are transient, you must report to the sheriff's office every 30 days, and you must report within 48 hours of establishing a transient residence. You're supposed to go to the sheriff's office and register. All right, good luck to you. Delvin Hayes?
Yeah, I just got to send something to Patrice.
Mr. Hayes, it's your present, Judge.
Okay, Mr. Hayes, you're here on a violation of probation. There's a no bond hold. However, you do have a court date on May 31st. Good luck. Vernon Ordain.
Patrice, do you still want it?
Mr. Alday?
Okay, I'll forward it.
Hello, Mr. Ordain.
Afternoon, Judge.
Okay, and
Judge, I'm actually a victim on this case.
what's your name?
Mike Jones.
Mike Jones. Okay, thank you for coming.
I was hoping before the court makes any determination, I spoke with Mr. Jones. There's just one brief specific fact I'd like to bring out through his testimony that I think is relevant to the offense charged.
Okay, you
Dealing
want me to
specifically with the knife that Mr. Aldain allegedly was in possession of.
place Mr. Jones under oath?
Please.
All right, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay, go ahead, Mr. Linzer.
Mr. Jones, you had an opportunity to read the probable cause affidavit with regards to the alleged armed burglary that occurred at your residence last night?
Yes, I did.
Okay, and it's mentioned in the probable cause affidavit that Mr. Aldain was in possession of an open blade knife that you observed when you entered your residence.
Correct.
Could you please describe for the court the knife that you observed?
The knife, it had some kind of a brown handle on it, probably about 3 or 4 inches in length, and the rest of the knife was, my guess would be 7 or 8 inches in length. It was not a folding knife. It was one you hold. It could not be folded.
Okay.
It was very sharp, pointy.
I have nothing further, Your Honor.
Okay. So, Mr. Ordain, after reviewing the complaint affidavit, the court does find probable cause. And is this a...
It is a punishable by life offense, Your Honor.
Okay.
Pursuant to bracket in Isaza, the state, for first appearance purposes only, would argue that a finding of proof evident or presumption great to hold a defendant no bond would be appropriate. The elements are satisfied in the probable cause affidavit, Your Honor. As you can see in the report, Mr. Jones kept Mr. Aldain at bay while police got there. They saw him. They found him at the scene. He had the knife in his possession. And the reason I wanted Mr. Jones to testify to the knife is so there could be no confusion about a possible either a pocket knife exception argument, Your Honor. Clearly, the description he gave, this would not qualify as a pocket knife.
Okay, thank you, Mr. Linder. Anything public defender wishes to add?
Just from a legal standpoint, Judge, if the state is asking the court to hold Mr. Aldain no bond, the court must make a finding of proof evident presumption great. The only evidence that's been presented to the court this afternoon is the probable cause affidavit and the testimony of Mr. Jones. Our position is that that is not sufficient for the state to conduct an Arthur hearing and determine proof evident presumption great, although we are asking you to conduct an Arthur hearing and not find that the state has met that standard. Under the Florida Constitution and State v. Arthur, proof evident presumption great is the highest standard that we have in the criminal court system, even higher than proof beyond a reasonable doubt. We would ask the court to set a reasonable bond for Mr. Aldain in this matter.
Okay, thank you very much. So, Mr. Ordain, after reviewing the information that's contained in the complaint affidavit and the additional testimony that was taken from Mike Jones, the court does find the proof of guilt evident and the presumption great to hold you no bond at this point. If you do or your attorney seeks an Arthur hearing, you may very well file a motion for an Arthur hearing in the trial division. And the court's going to order, well, no contact.
Just an abundance of caution, both no victim contact and no return to the residence.
Okay, no victim contact at all and no return to the subject residence, Mr. Ordain.
Judge, just a point of fact, he was there 3 nights in a row. He broke into the home 3 separate occasions.
I have to
finally
object to
got him
this,
on the third
Judge.
night.
This is not an appropriate time for comments such as these to be made. The court has already made a ruling.
All right, Mr. Jones, he's being held no bond.
I understand, Judge. I know how it works.
Okay.
All right, thanks, Judge. Good seeing you.
Carl McKay.
Mr. McKay is here, President Judge at Maine. He declined the service of public defender.
Okay. Mr. McKay, you are here on selling Schedule 1A, B, 2A, B, C, and 4, and C4 drugs within 1,000 feet of a school or a park, and you also have a violation of probation. Now, State, on charge number 1, is this it's an arrest warrant with no bond?
Is he
entitled to a bond?
Yes, he is, Judge.
Okay, and what is the state's recommendation for a bond on charge 1?
Your Honor, considering what he's on probation for, and this is a first-degree felony, I'd request a $10,000 bond.
Okay, Mr. McKay, anything you'd like to say to the court?
Yeah, I wanted to ask, last night when I got arrested, like the agency that came and arrested me said BSO placed the warrant, but they're not the one that wrote the warrant or something. I was wondering what city that warrant came from.
Okay, you have an arrest warrant that was signed by a judge.
It was through the law enforcement agency with Sunrise Police Department.
Okay, it was Sunrise Police, but it was signed by a judge. Okay, so I am going to set bond on count 1 in the amount of $10,000. You are being held no bond on the probation violation, but you are going to court on May 30th.
Okay.
Okay, good luck, sir. Joseph Theodore Arena.
Mr. Arena is here, President Judge at Maine.
Okay, thank you.
And his attorney is here, President.
Okay, hello, sir.
Good afternoon, Your Honor. Elias Hilal on behalf of Joseph Arena.
Okay, I'm sorry, what's your name?
Elias Hilal, Hilal.
Okay, and you are counsel for Mr.
I am
Arena?
the attorney for Mr. Arena, correct, Your Honor.
Okay, excellent. Mr. Arena, your attorney is present in court, and Mr. Arena is here on a probation violation. Counselor, is there anything you
Yes,
wanted
Judge,
to
this
advise the court?
violation is pursuant to 948. It was not a judge-signed violation. Right? It appears that a police officer may have found some sort of violation pursuant to what is in the police affidavit or the complaint affidavit. I asked the court to, after reviewing the police affidavit, to not find any probable cause or any reasonable grounds to believe that he violated his probation. Under the statute, this court, at its first appearance, has the ability to determine whether or not reasonable grounds suffices as to whether he violated his conditions of probation. Reviewing the affidavit itself, the only indication the court has to rely on it is a statement allegedly made by Mr. Arena saying that he knew they had weed in the vehicle. Judge, slight only basis on that, Judge. I don't know if the court is going to find that that's enough probable cause in order to determine he violated probation. Secondary, we don't have any evidence before this court to suggest that that's a condition of his probation anyway. They can make an argument that it's standard condition of probation, but this court must make a finding further than that and actually know that police officer had knowledge of what Mr. Arena's conditions of probation actually were. Hence why a lot of these go before a court. The court would be able then to review what his actual standards of what his conditions of probation were and then violate them. But now what this officer is asking the court to do is to make the assumption that this officer, at the time he detained Mr. Arena, one, this court must find that that statement was actually made, which makes no sense. But then two, that the actual condition of his probation was he could not be in possession or within someone that has, I guess, a drug, right? This is a hold out of Leon County. So in essence, what would happen is Mr. Arena would sit in custody for X amount of days till he's traveled up. This court has the authority to enter bond, to grant bond in this case, to allow Mr. Arena to go to Leon County to appear before the judge in that county, as opposed to sitting in custody for 30 days or however long it's going to take for them to transport him up to Leon County, based on an alleged statement.
Okay. All right. Thank you, Mr. Halal.
Your Honor, as far as probable cause, the basis for the court to determine, it's based on the allegations. What the officer did or didn't know, or what he believed or didn't believe, is immaterial. It's if the allegations, as presented to the court, satisfy the offense or the charge, In this case, it's a violation of probation. It is a standard condition of felony probation that you are not to engage or be around people that are committing criminal acts. His statement that he knew the driver of the car had weed in the vehicle is an admission of a violation of his probation, Your Honor. That being said,
I mean, don't say anything.
I would argue, if the court does find probable cause, then that because this is out of Leon County, his judge that put him on probation in Leon County should be the one to decide if he should be released or not. Just like if somebody on Broward County, probation out of Broward County got arrested in Leon County, I would hope that the Leon County judges wouldn't make determinations for whether someone should be held or not on a Broward County probation. I can tell you, should the court decide to find probable cause and order him to be held, the next step is BSO will contact the Department of Corrections in Leon County, get in touch with his probation officer, who will decide either to prepare a warrant or not prepare a warrant. If they decide not to prepare a warrant, he'll be ROR. If they decide to prepare a warrant, they will go to the judge, and then that bond, or whatever the judge sets on the warrant, we place on Broward, and if it's no bond, Leon County will pick him up. I don't know if it's going to be 30 days. I don't know. I did mention in counsel, if the court does order him to be held no bond, he could certainly be proactive and contact the probation officer in Leon County himself to see if the process can get moved along. But how long it's going to be, I don't necessarily believe is a key to the determination at this point in time.
Okay, thank you. All right, after reviewing the arrest affidavit, the court does find probable cause to indicate that the police officer had probable cause to believe that he was engaged in criminal activity with the admission and with finding marijuana and pills in the car. The court is going to hold him no bonds, and I would suggest, Mr. Halal, that you do contact probation from Leon County and move the process along. That's it.
Thank you, Judge.
All right. Delvin Markin Williams.
Mr. Williams is approaching, Judge.
Thank you. Okay, Mr. Williams, you're here on a burglary of an occupied dwelling charge and petty theft. The court does find probable cause. I am issuing bonds in the amount of $10,000 on count 1 and ordering no return to the subject property.
Judge, in speaking with Mr. Williams, he advised me he's been residing in South Florida his whole life. He's 37 years old. He is working. He works at a car wash. He's been working there for about a few months. He gets paid by the vehicle, about $5 a vehicle. Judge, it's basically minimum as far as his financial resources, no money in the bank, no property. He lives in Allendale with his aunt. Judge, we'd be asking you to consider reducing his bond to something more attainable for his aunt to potentially post. We'd be asking you to consider setting a $2,500 bond on his behalf.
Okay, let me hear from the state.
Showing is, it appears, let's see what the basis was. Recently, 2014, Your Honor, he had 2 burglary dwellings, one of which was occupied, dismissed on competency grounds. 2013, he was convicted of possession of cocaine. In 2011, he had a felony battery on a victim over the age of 65, dismissed on competency grounds, and a burglary dwelling in 2010, dismissed on competency grounds, and a loitering and prowling. He was convicted of burglary of a dwelling in 2007. 3 separate possessions of cocaine in 2006. He was convicted of another burglary of a dwelling and grand theft in 2006. A loitering and prowling in 2007. Theft 2006. Resisting without violence 2006. Had a cell delivery of cocaine within 1,000 feet of a place of worship in 2004, dismissed on competency grounds. A couple thefts in 2004. Another theft in 2003. Burglary of a conveyance where he violated probation in 2001. Your Honor, I just ask that the court keep your original bond in place.
Okay. The court is going to leave the bond set at $10,000. Good luck, Mr. Williams. Michael Collins.
Mr. Collins, come on up, please.
Hello, Mr. Collins.
How you doing?
Well, thank you. You're here on a possession of cocaine charge, resisting without violence, and you have 2 traffic tickets. The court does find probable cause. You have bond set in the amount of $1,000.
Judge, he's asking if you would consider pretrial. Financially, he can't afford a post bond. He works, he's a day laborer. He gets paid approximately $80 per day. He lives in an apartment. He's been residing at the same apartment for the past 3 years. His share of the rental expenses is about $200 per month. He has no one to help potentially post his bond. Considering he has an address, he's asking you to consider pretrial release, and we'd be asking you to sign a photo order, Judge.
Okay. Is he eligible for pretrial? What was the resolution of the...
Do you have his Broward priors? Oh, sorry. 2015 possession of marijuana, 2014 possession of cocaine.
All right. Mr. Collins, with the prior possession cases you had, the court's not going to refer you to pretrial. It's going to be a $1,000 bond. Good luck.
And you will in the photo order, Judge?
I will grant your request. Kenneth Lindley Hodge.
North Broward.
Okay.
That's a medical reset, Your Honor.
Okay, thank you. Jamar Anel Odom.
Mr. Odom's approaching, Judge.
Okay, thank you. All right, Mr. Odom, I was just advised that your bond is being posted as we speak.
Good luck, sir.
Good luck. Jose Luis Ruiz.
Sir, main judge, he's approaching.
Okay, hello, Mr. Ruiz. Mr. Ruiz, you're here on an aggravated battery with a deadly weapon charge. The court does find probable cause. And I am setting...
Your Honor,
Yes.
the state is, does pretrial have a criminal history? I don't believe he does. Sorry. Yeah. Yes.
2004 was a felony theft, grand theft of a motor vehicle. He was adjudicated. 2004 offense of cocaine, burglary, adjudication, occupied structure. Went to prison in 2007. Was released from custody in 2008. Arrested in 2009 for hit and run, failing to stop on me, and a crash involving me. Court want me to keep going?
Your Honor,
That's
based
sufficient.
thank you. Based on his criminal history and the level of violence alleged in this case, I do believe Mr. Ruiz poses a danger to the community. I'd request a $25,000 bond. Should he post his bond, pretrial release with a GPS monitor and no victim contact.
Okay. Anything from the public defender?
Yes, and speaking to Mr. Ruiz, he advised me that he's been residing in our community for 20 years. He is 31 years old. He's currently working. He works part-time. He works part at the Dollar Tree. He's been working there for about a year and a half, making $8.15 an hour. Financially has no money in bank, no property. Also advised me that he's currently going to school. He's attending Butler Academy. He's been doing that for the past 2 weeks now. He lives in Fort Lauderdale. Him and his girlfriend reside together. They've been residing at the same location for about 11 months. They split the rent 3 ways between him, his girlfriend, and the father of his girlfriend. His portion is about $300 per month. The judge advised me financially he can't afford to post bond. His girlfriend can't afford to help him. He's requesting you consider pretrial release.
Okay. Number one, the amount of priors that pretrial has advised the court of, I am not considering pretrial release. Number two, after reviewing the probable cause affidavit, if it's true, what I read here, I do believe that Mr. Ruiz is a danger to the community. I am setting bond at $25,000. I am wondering if he is released on bond, that he will wear a GPS monitor through pretrial, and he is to have no contact with the alleged victim, Miguel Angel Lopez. The court will grant the public defender's request for photographs.
Thanks, Judge.
You're welcome.
Line is up now.
Okay.
Judge, we're done here at Maine.
Yeah, we're done. Okay, thank you very much. Okay, I have the motion for ROR. Bobby Jackson?
Conti, Your Honor.
Okay, thank you. Okay, hello, Mr. Jackson.
Hello, good evening.
Good evening. Okay, Mr. Linder, I need your assistance. We're here on Bobby Jackson on the defense motion for ROR.
Yes, Judge, I'm looking that up right now.
Okay, we're going to see if your attorney filed a motion for you to be released. I'll be with you one moment.
Yes, ma'am.
Has not been filed. He's entitled to an ROR at this time.
All right, the court's going to grant your counsel's motion to release you ROR on these 3 counts.
Thank you, Your Honor.
You're welcome. Good luck. Alan Wolski?
Conti again, Your Honor.
Okay.
Hello, Your Honor.
Hello, Mr. Wolski. Mr. Wolski, you're here on a possession of cocaine matter, and you're also here on a motion for ROR.
Has not been filed. He's entitled to an ROR in this charge.
All right, the court's going to grant your attorney's request and release you on your own recognizance on this charge. You're welcome.
Thank you.
Bianca Bailey?
Paul Ryan.
Hello, Miss Bailey?
Good afternoon.
Miss,
Has not been filed.
okay, Miss Bailey, you're here on a possession of cocaine and drug paraphernalia charge. Your attorney's filed a motion for ROR. The court's going to grant the motion and release you on your own recognizance on these 2 charges.
Thank you.
You're welcome. Matthew Doty.
Conti, Your Honor.
Okay.
Your Honor, this is actually a second look. Frankly, I'm kind of surprised. I didn't think second-degree felonies were eligible for felony second looks.
Hello, Mr. Doty.
How you doing, ma'am?
I'm well, thank you. Okay, Mr. Linder, you said this is on for a second look?
It's on for a second look. The top 2 counts are second-degree felonies. One moment. Actually, his bond was increased on, actually, the first 3 counts are second-degree felonies. His bonds were increased on all 3 to $5,000 each. Your Honor, I would be asking the court to leave the bonds where they were originally set.
Okay. Does the public defender wish to be heard?
No, Your Honor.
All right, Mr. Doty, anything you'd like to say?
I can't bond out. Even if it was $100, I wouldn't bond out. I just live with my mom. She's dependent on me right now, and she's scared and she misses me and wishes I was home. I was eligible for pretrial release. They asked me yesterday if I wanted to be if I'm interested in pretrial, and I just want to start over and start new. And I need help. I'm 22 years old. I weigh 106 pounds right now. I've detoxed now, and I'm just want to start over and help my mom and step up and be the man of the house, because my mom's the only family I have down here in South Florida, and the only family I have. And This is just, I've messed up so bad, and I just want to start over, man.
Was he referred to a pretrial?
He was interviewed by pretrial, yes. I'm not making any recommendation. If the court wants to release him to our supervision, that's fine. But we are not making that recommendation.
Okay, and does he have any prior state?
He's got a couple prior thefts, but Your Honor, you should also know, this wasn't, a matter of one incident and he got arrested. Hollywood Police Department had been investigating him as a known heroin dealer in Hollywood. There's been, through a CI, it looks like more than one deal. He had 2 heroin purchases. As far as whether, but he says he couldn't post a $100 bond. I don't know that that's the case. According to the report, when they obtained a search warrant to his residence in his room, 4 cell phones, a scale, a glass crack pipe, several bags containing suspect heroin, 1 baggie containing an unknown white powder, morphine pills.
I'll tell you what. I am going to refer Mr. Doty to pretrial.
Thank you, Your Honor.
You're welcome. I'm going to give you a chance, Mr. Doty.
Thank you, ma'am. I won't let you down.
I hope not. Thank you. Thank you.
Your Honor, is that standard pretrial? Or is he going to wear an ankle monitor?
Since these are second-degree felonies, Your Honor, then I would ask for an ankle monitor.
Okay, I am going to require that you wear an ankle monitor.
That is no problem, ma'am.
Okay, good luck to you.
Thank you.
Yes, and Mr. Doty,
Yes, ma'am.
based upon the charges, you are going to submit to drug evaluations,
No problem, ma'am.
get you detoxed. Okay.
Would the court consider waiving the $5 a day fee for the ankle monitor?
Yes.
Thank you, Judge.
Thank you, ma'am.
All
Good
right.
luck, ma'am.
You're welcome. Good luck.
Thank you.
William Carey?
Second look as well.
Thank
Yes,
you.
Your Honor.
Okay, Mr. Carey, you're here for a second look on a grand theft charge, and state what is the story for Mr. Carey?
He's got a $1,000 bond.
How much is his bond?
$1,000. He's had 2 thefts, one in 2015, 2016, and now this grand theft. Let's check and see what the allegations are. Saying he stole power drills from Home Depot, valued at just under $900.
Valued at just under $100?
$900.
Oh, $900. Okay. Public defender wish to be heard?
Judge, get a chance to talk to the second look people because I just get those dockets as I get to the courtroom, so I haven't had a chance to talk to Mr. Carey, although I think I remember him from being here not too long ago. I remember that probable cause affidavit.
All right, Mr. Carey, you have a $1,000 bond.
Yes, Judge.
Okay. Good luck to you.
Okay, thank you.
You're welcome.
This morning. You don't forget the